When an FBI director lies twice to Congress in a single hearing, that's not just perjury. It's a constitutional crisis. Senator Whitehouse just exposed Kash Patel's web of deception about grand jury testimony, court orders that don't exist, and transcripts that were never released. What you're about to see is the methodical destruction of a nominee who thought he could lie his way to the top of America's premier law enforcement agency.
Thanks, Chairman. My comments today about FBI chiefs testifying honestly and not lying to Congress are particularly relevant in light of your opening statement. Let me start with the basic fact behind all of this, that the current FBI director pled the fifth in the matter where he ended up providing grand jury testimony. We've never had an FBI director come through this committee who had pled the fifth before. As you know, when you plead the fifth, to do it honestly, you have to have a good faith belief that your testimony would subject you to criminal liability, which meant if Patel was being honest, he had a good faith belief that his testimony would subject him to criminal liability. As that went forward, he ended up getting immunity from the government in order to testify. If this were a court, a civil court, a judge would allow an adverse inference to be drawn against the witness who had asserted the fifth. In Patel's proceedings, we were never even allowed to get to the bottom of the grand jury testimony. Why he pled the fifth, what he said, all of that was papered over as he went through this committee to confirmation. So for obvious reasons, I pursued that question, just as you would, Chairman, if the shoe were on the other foot. And I believe that Patel lied to us in the committee. He said that he couldn't share his grand jury testimony, and I'm quoting him here, because there's a court order on that case, he said. He said again, I can't go into court orders granted by the DC District Chief Judge. And then when I pressed him further, he challenged me saying, you want me to violate a court order? He then went on to say to Senator Booker that his grand jury testimony has been sealed by the Department of Justice, and I'm not allowed to discuss it here. Well, as it turns out, none of that was true. All of that was false. And we know that because the DC District Chief Judge, who he mentioned in his false statement to this committee, said, and I'm quoting the judge, July 2025, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee, unquote. So it sure looks like he lied about that. So in his recent testimony, I asked him again. And now he offered the committee a new and different lie, which is that he had released the transcript already. He said, first of all, I'd love my grand jury testimony to be released. I want it made public. And then he said, I wanted the transcript released, and I will get it to you, sir, to me. I wanted the transcript released, and I will get you the transcript. He said to me, we can confirm that pursuant to my action, that grand jury testimony has been released, the transcript. He said the transcript has been released publicly. He told Senator Booker, well, I don't have the grand jury transcript. That's why I released it. So, as it turns out, no transcript was released. He was making up that lie probably to get away from having to answer our questions. But now we have an FBI director who first lied in committee about a non-existent court order and had that lie exploded by the actual judge who he claimed had him under court order, and then lied in committee about having released a transcript that we all know has not been released. I think on that state of facts, we're entitled to get the transcript that he says he wants us to have, that he says he released publicly, and that the judge has confirmed is not under any court order of protection. So, Mr. Chairman, I look forward to working with you. I know you have a strong interest in FBI chiefs testifying honestly in this committee and not lying to Congress to try to get to the bottom of what is going on, because those seem like two pretty flagrant and obviously provable lies. And we'll follow up for further assistance to get to the bottom of this. But I don't think it's asking too much to ask the committee's support, to ask Director Patel to do what he says he has already done, which is to release the grand jury transcript of his testimony and provide it to us. Thank you.
What Senator Whitehouse accomplished in that hearing wasn't just political theater. It was a masterclass in exposing how someone unfit for office tries to manipulate legal procedures to avoid accountability. Let's break down exactly what happened and why it matters for every American who believes the FBI should operate independently. The foundation of Whitehouse's case rests on a simple legal reality that most people don't understand. When Patel pled the Fifth Amendment before the grand jury, he was making a specific legal claim under the Constitution's protection against self-incrimination. You can only invoke that protection if you have a good faith belief that your testimony would incriminate you. That's not a casual decision or a strategic delay tactic. It's a formal admission that you believe answering questions could expose you to criminal liability. The legal standard is clear. You must have reasonable grounds to fear that truthful answers would furnish a link in the chain of evidence needed to prosecute you for a federal crime. But here's where the lies begin. Patel told the committee he couldn't discuss his grand jury testimony because of court orders and DOJ secrecy rules. That's completely false. Federal Rule 6E explicitly allows witnesses to discuss their own testimony. The only people bound by grand jury secrecy are prosecutors, court staff, and jurors, not the witnesses themselves. The D.C. District Judge confirmed this publicly, destroying Patel's first fabrication. When cornered on this lie, Patel didn't come clean. Instead, he created a second lie, claiming he had already released the transcript publicly. That transcript doesn't exist in public records. No release occurred. He was manufacturing a story in real time to escape scrutiny. This pattern reveals something more dangerous than simple dishonesty. It shows someone who understands legal procedures well enough to manipulate them for personal protection. Patel used the complexity of grand jury rules to mislead senators, betting they wouldn't fact-check his claims. When that failed, he invented a non-existent transcript release. Why does this matter? Beyond Washington politics, the FBI director has unprecedented power over investigations that can make or break careers, determine prosecutions, and shape national security policy. If that person is willing to lie to Congress about their own legal accountability, what happens when they oversee investigations involving political allies or enemies? Consider the chilling effect on career agents and prosecutors. When leadership demonstrates that truth is negotiable, it corrupts the entire institution from top to bottom. Line prosecutors start self-censoring their cases, looking over their shoulders before pursuing politically sensitive investigations. Agents hesitate to follow evidence where it leads, especially when it might implicate powerful figures. The result isn't just bad for justice. It's dangerous for national security and public safety. This erosion happens gradually, then suddenly. First, a few prosecutors avoid certain cases. Then entire units become reluctant to investigate connected individuals. Eventually, you have a two-tiered justice system, where your political connections determine whether laws apply to you. We've seen this pattern in other democracies, and it never ends well for ordinary citizens who depend on equal treatment under law. Whitehouse's methodical approach also exposed a deeper problem. Patel's lies weren't spontaneous mistakes under pressure. They were calculated attempts to avoid transparency about his role in politically sensitive investigations. Someone seeking to lead the FBI should welcome the chance to explain their past testimony, especially if it clears their name. The stakes here extend far beyond one nomination. We're watching a test case for whether institutional integrity still matters. If nominees can lie repeatedly to Congress about verifiable facts and still get confirmed, it sends a clear message that truth is optional for those in power. The solution Whitehouse proposed is straightforward. Release the transcript that Patel claims he already released. Let senators and the public read what he actually told the grand jury. If his testimony was proper and professional, transparency helps him. If it wasn't, the American people deserve to know before handing him control of the FBI. This isn't about partisan politics. It's about the basic requirement that law enforcement leaders tell the truth to Congress. When that standard disappears, we don't have an independent justice system anymore. We have a tool for whoever holds political power. Democracy depends on institutions that put truth above loyalty. Whitehouse's questioning wasn't an attack on Patel personally. It was a defense of the principle that no one, regardless of political backing, should lie their way into running the FBI. If we accept those lies as normal, we've already lost something essential about how justice works in America.